Okay, see? Okay, my husband there trying to fix the banners. Okay, it's still September 15th, Wednesday, 2010. This is Roxanne Grinage. My banners fell down. And my husband put them up. He doesn't want to be on camera. Can you blame him? Okay, now. Okay, all right, let's get back to that. Here's an administrative solution. I keep talking about standard access. How is quality of life raised when you have standard access? What is the disadvantage? Who is the disadvantage creator? The disadvantage creator is the person who's creating something, an original creative work product contribution, that does not have control or influence over the processes and venues that suck it up, that use it, that consume the product. All right, they have no control over compensation or recognition, rights, ownership. Okay, so Higher Lyrics started in 2000 a standard access mechanism to say, how can we make protection of rights ownership available for lyricists? That was our challenge. That's what we were noticing in our community where we were at. The hip-hop lyricists specifically that had this great work product contribution, quality of life impacting messages, product contribution into education. Education is an industry. But they were challenged to have their rights protected because they couldn't be seen by the litigation industry, who had no mechanism for taking on the merits of their case contingently without having to lay out sums, to pay the attorney per hour, because the attorney had expenses, overhead and cost expenses, even researching the merits of the case. He had to pay his staff, paralegals, and so on, appearance fees, just functioning. So we sought out Higher Lyrics that if we could find some way to allow creators of original creative work products to standardly present, regardless of who they know or what they have, whether or not their mother or father had money to take a second mortgage out on their house to get the studio time, whether or not they knew the right people, whether or not they knew the right names to drop, whether or not they could many times get a gig, they could get a job, they could get a booking in a club for maybe a week, but they didn't have the proper gear, they didn't have the mic, they didn't have the things that they needed for their studio basement, for their little basement studios, to produce their own product and control their own product. And as they were going around laying all this money out that they had earned on their own behalf, that they had worked so hard in their own collaborations, doing the right thing by each other, groups of 3, 4, 6, 10, 12, right? They had no way to manage through contracts and agreements the administrative end of recognition and compensation. And they do need, this population does need litigation industry professionals. It needs it, but the challenge is getting the litigation industry to see a population of claimants who don't have money to lay out to talk to the attorneys. So it was very obvious that attorneys could see the merits of say an auto injury case, automobile accidents, injuries, and so on. That was obvious. Or personal injuries, slip and fall. You can see that. You can see medical malpractice. Oh yeah, we can prove this. We can order the medical records, and we could put this case together, and we can sue these people, and they may settle, they may not, but there's going to be some earnings as a result of our work, and we can embed a percentage ownership on a contingency fee agreement. But administrative services had no way to do that. Administrative services had no guarantee that their work would ever be taken on by any professional. Litigation industry, education, 12-step recovery, engineering. These are the industries, small business development, community development, life experience, mentorship, expertise. These are industries. Litigation is an industry. And after you set up the work and the work product, how do you get the industries to see that you have something marketable into their industries? No, we're not attorneys. No, we're not qualified to litigate the case, but we are qualified through expert certifications and 10 years experience in evidence gathering, depositions, and expert witness testimony, among other areas of administrative practice for which we're certified expert, to document and record the merits of the case that qualified litigation industry professionals can look at and see, oh, this is suitable for going to court, this can be taken on responsibly, practically, contingently, this bears some risks, monetary risks. So, again, Higher Lyrics, me, Roxanne Grinage, managing Higher Lyrics Administrative Services, said, what is available out there free and low cost to provide standard access? How can we get a pool of potential claimants that are struggling from check to check, but are in fact creators of original creative work products that are reinventing themselves? They're demonstrating acts of resourcefulness, talents and skills that are never documented. They don't have their rights of ownership to these skills. How someone in their 20s, welfare to work program, stretching macaroni and cheese and going to school to keep their menial benefits, how they actually have a project manager's demeanor, and they would be a right fit for coming in under budget to a corporate employer who is concerned about meeting budget guidelines, and maybe all they need to fairly compete into corporate employment, salaried employment with a benefits package and a 401k plan is the advancement of an accounting trade school course. You know what I mean? 6 months or a year, or an AA degree, whatever that means. And that's an advancement, and we demonstrated over these 10 years that when you advance the services, you advance the work, or you advance the fees, it is not welfare or charity, because it's actually a billable cost that is recoupable, that is unlocking your client's contribution back to you. You did it contingently. There will be a payday. There will be a settlement. There'll be a win or a settlement. There'll be a job placement. There'll be litigation. And if you did that resume contingently, or you took on that case contingently with the data, right, that you can sign that standardly accessed potential claimant to a contingency agreement that says, when you actually receive earnings as a result of the work we did for you, then we get paid and we recoup our costs. And it is a sound practice model, because it unlocks untapped economy contributions. It unlocks revenues both for the claimant side, the original creative work products, and yes, people creating families have an original creative work product. Okay? And their challenge is that they have no say in who takes their vested interest in that product, in that family that they worked to bring here, that came through them, and they have no say when it's taken. In this case, what needs to be litigated, the litigation industry needs to, the challenge is, how do we get the litigation industry to fight for our state and U.S. constitutional rights that have been violated, you know, by a state agency financially driven. Okay, I think I'm over 10 minutes on this one. And this is the standard access form. Look at some other videos and come to my blog talk radio show this Sunday particularly, because we're going to show how you go through the internet process to set it up. Any paralegal can do it. Any person with secretarial skills can do it. How you would just be opening a file with the anticipation and expectation. What does this attorney need? What does this ethical, qualified law firm need to assess the merits of this case, you know, to see whether or not they want to take this on. So we're going to do that for this particular case. Is going to be here in Michigan, all right? A Michigan victim, and it's going to connect, it's going to show the data of how we've developed and learned through standard access and publicly posting to a demonstrated administrative solutions tool we call the U.S. Citizens Control Public Docket Database.